Hello, my name is Liz Smith, and it's actually last week was Estate Planning Awareness Week, and this year we're focused on estate planning for growing families. I am recording a presentation for anyone who does have a growing family to get this information out there and see if we can help you. So this will just be a pretty quick presentation. I'm sure you are busy if you are growing your family, but just quickly, my name is Liz Smith. I'm the CEO and founder of 49th Estate Planning. And I got started in this career. I live in Juneau, but we serve clients throughout Alaska. And I got involved in this field after about 10 years working for the state and deciding that I actually really wanted to work for myself and run a business. But once I made that realization, I thought I had no interest in doing estate planning myself. I didn't want to work in private practice mainly. I didn't want to bill clients by the hour, and I didn't want to work in conflict, but I found that this field allows us to help avoid conflict by assisting clients to have a plan in place, which is really what this presentation is all about, is creating a plan just in case something happens to you. And then, of course, when at some point later in life, we're really planning for that transition on. And right now in your life, if you're expecting we're in the process of expanding your family. You're really going to be focused on the what ifs, which can just be such a gift just in case something did happen to your family. So we'll talk more about that. But at 49th Estate Planning, part of why I didn't want to do private practice is I didn't want to do hourly billing. I have a good friend whose father paid over $5,000 for an estate plan with the goal of keeping family out of court and out of conflict, only to discover when her dad died, they were in court for years, trying to wrap things up, but also arguing with his ex-wife, which is what he had been trying to avoid. And what my friend realized, she thought, well, this must be malpractice, what the attorney did, but it was really common practice. The attorney had prepared documents, but not done any follow-up to make sure the plan would work when needed. And so we have a system to, first of all, we do everything flat fee, and then we try and help our clients with, we have a huge team, and the goal is that we have staff that will help you make sure that assets are aligned with how your plan is. And that's going to be really, really important if you have a minor child, to make sure that your wishes are honored if something did happen to you, and also that your healthcare and financial decisions would be made how you want them if something happens to you. All right, let me just dive in and get started here. Congratulations on attending this presentation. The addition of a new child is an exciting time for any family. With all the preparations for a new child, it's important that your estate plan also reflects this new addition. Most of you have probably had this exact thought when someone has started talking to you about estate planning. Do I need an estate plan? Really? Like, why? You may think you don't own enough to have an estate plan prepared, or that your loved ones already know your wishes, so there's no need to put them in writing. But with the addition of a new family member, now is the time to make sure that all of your wishes are in writing and legally enforceable in the event action needs to be taken. For those of you who already have an estate plan, you may think that you are already in the clear. However, a new addition brings additional planning considerations, and you need to make sure your estate plan still expresses your wishes. While creating an estate plan may feel overwhelming, it is worth the effort when you consider what will happen if you do not have your wishes expressed in a legally enforceable way. Without an estate plan, you have no control over what will happen when you die. The control will reside with the probate court, state law, and the court-appointed guardian and conservator. In addition, the additional administrative costs can be large and can eat into what you had intended to leave for your child. Another often overlooked consideration is that because a court may scrutinize the management of the child's inheritance, there may be a delay in implementing new investment strategies, or the court may not allow some investment strategies. Without an estate plan, the probate court will be making important decisions for your child and your family. They will be choosing who raises your child. This is largely determined by state statute, giving priority to blood relatives, whether that's who you want or not. The person may or may not have been someone you would have chosen, and without an estate plan, you cannot weigh in on that decision. The court will also be monitoring your child's inheritance. This means they may be determining what the money can be used for prior to your child becoming an adult. The judge may not share your views on what expenses are appropriate and may deprive your child of funds for things you would have wanted them to have. The court may be involved with your child's matters until they become an adult. This may involve requiring periodic filings with the court and court hearings, all of which will take time and cost money. Other parties who will have a lot of involvement are a court-appointed guardian and conservator. The guardian will be in charge of raising your child and caring for them day to day, while the conservator is tasked with managing the money on your child's behalf. These roles may be filled by the same person or two different people. These roles are usually filled according to state law, which may result in the appointment of a person or people you would not have chosen. The conservator will be in charge of how the child's inheritance is spent. Without any instructions from you, the conservator will have to use their best judgment. This means that things you wanted your child's inheritance to pay for may not end up being paid for with the inheritance. Conversely, things you would have never allowed the inheritance to be spent on might be purchased, as long as they are reasonable. The person selected as your child's guardian will play a large role in your child's life, even if they are not the ones controlling the money. They will be residing with your child and in charge of all decisions regarding their education, health, and welfare. How they raise your child will directly impact your child's future. Without any guidance from you, all you will be able to do is hope that the guardian raises them similarly to how you would have. Because of the court's involvement, there are rules that may have to be followed regarding investment choices and when the child receives their inheritance. The court may have to approve decisions regarding your child's inheritance. Also, the court may limit the types of investment strategies that can be used when managing the child's inheritance. The lack of flexibility in investment strategies may mean that your child does not have enough money to go to college or pursue any of the other things you had hoped for them. State law will also dictate when the child receives inheritance. In Alaska, your child will receive all remaining inheritance once they reach age 18. Once this happens, your child is able to spend whatever is left of their inheritance in any manner they choose. Their inheritance may not be protected from your child's creditors, a divorcing spouse, or lawsuits. Now that we know what will happen if you do not have an estate plan, let's look at what the outcome will be if you do have a plan. First, an estate plan allows you to put your wishes in writing in a way that is legally binding. Your loved ones will know what your wishes are, which can make it easier to follow and also eliminate potential conflicts down the road. You can also use your estate plan to highlight things that matter most to you. In other words, education, volunteering, family get-togethers, etc., and provide a way for your child to experience things although you are no longer with them. Creating an estate plan puts you, rather than a court and state law, in the driver's seat. First, you can nominate someone to raise your child. Although the court will still have to officially appoint the guardian, you have the ability to weigh in on the matter, and your nomination can be given great deference. Next, you can decide who will manage your child's inheritance. To avoid too much court involvement, you may decide to have the inheritance held in a trust for your child, with a trustee in charge of managing and distributing the money. You can also protect your child's privacy. Although court involvement will be required to appoint a guardian, you can keep some of your financial information private if your child's inheritance is managed through a trust. Using a trust allows you to provide specific instructions for how the inheritance will be used. The instructions you provide can help direct your child's future by encouraging them to do things you believe are important, like pursuing higher education, being gainfully employed, or volunteering. It also allows you to direct the trustee to make funds available for other important events, such as a first wedding or starting a business. Let's go through a few different examples of what that might be helpful to you. So scenario 1, Jason and Samantha just welcomed their second child, David. They have one other child, Stella, who is 7 years old. Neither Jason nor Samantha have living parents. Jason has one sister, Diane, and Samantha has 2 brothers, Ethan and Liam. Diane is married with 3 small children. Diane seems constantly overwhelmed with her own family, though she is a loving parent. She also has a fulfilling career as a neurosurgeon and is financially stable. Ethan and Liam are both single. Ethan owns his own plumbing business and has a serious girlfriend and a son from a prior relationship. Liam is a real estate investor, lives by himself, and has expressed that he never wants children. Without an estate plan nominating guardians for David and Stella, a court would have to decide who, among Diane, Ethan, and Liam, would be best suited to be the guardian of the children. The court might decide Diane is the best choice. But Diane is the last person Jason and Samantha would ever want raising their children. She's never home and has several nannies that help her. Diane and her husband have also been separated twice. Jason and Samantha worry that Diane would agree to be guardian out of guilt or obligation, though she probably couldn't handle 2 additional children given her already busy lifestyle. Liam doesn't want children and would not be the best choice for the children. Ethan would be Jason and Samantha's first choice. They really like Ethan's girlfriend. They've been dating for 6 years and have recently discussed marriage. Ethan is a loving, attentive father, and Ethan's business is successful and well run, leaving him financially secure with a lot of free time to parent. Jason and Samantha's guardianship nomination in their wills would memorialize their wishes that Ethan be the guardian of their children. Without this information, a court can only make decisions based on what they see on the surface, which in Jason and Samantha's case might result in less than desirable consequences for their children. And another scenario 2. Susan has 2 children and is a widowed single mom. She needs to name a guardian for her minor children. She has 2 sisters, Carrie and Tracy. Carrie is well off thanks to a favorable divorce settlement, does not work, and generally lives a life of leisure. Tracy is the total opposite. She recently adopted a boy from the foster care system who has special needs. Although she is a hard worker and passionate about her job at the museum, she does not make much money. According to many courts, Carrie would be the better guardian. But Carrie is the last person Susan would ever want raising her kids. They don't share the same values of respect for hard work and principle of kindness towards others. Susan also fears that Carrie would want to be guardian to gain access to the trust fund set up for her children so that Carrie can supplement her lifestyle. Susan's guardianship nomination and her will would speak to the court for Susan when she cannot. Without this information, a court can only make decisions based on what they see on the surface, which in Susan's case could have disastrous consequences for her children. So let's say you already have an estate plan set up. Just transitioning gears just a little bit. If original documents were prepared that incorporate any previous children you may have, the general assumption is that any additional children will be treated the same, and the amount will be divided between the existing children and additional children. When reviewing your estate planning documents, you need to ask yourself if the current language still makes sense. If there is a large age gap between children, they may have different needs, necessitating different distribution schemes. If one of the children has special needs, specific language needs to be used to avoid disqualifying them from government benefits. If you've already nominated a guardian for your older or other children, you should check with that guardian to see if they would be willing to take on one more. They may not be able or willing to do so. Maybe they have children of their own, or maybe one more child will not work with their desired lifestyle. A person may have agreed to be named as the guardian when you only had one child, but with 2 or more, they may have reservations and you may need to approach other potential guardians. If this leaves you curious about what will happen in your situation, and you're interested in exploring whether you need to update existing documents or you just know that you want to get something in place and haven't been doing so. You could be pregnant knowing that a child is coming, or you might have a 16-year-old at home and know that getting a plan in place has been on your list for a long time. Here at 49th Estate Planning, we make things as easy as possible, I believe, to get a plan set up. So here we have a system in place. If you contact our office, we will be in touch, get you scheduled for an appointment and walk you through the entire process. You just need to prepare some information, answer our questions, but we walk you through. If you would like to get started, you can go to our website, and we'll, I'm sure, provide a link here with this video to schedule a 15-minute call with an intake coordinator who will talk to you about our process and get you scheduled for a meeting with an attorney. Mention this video and we will give you $250 off planning if you decide to work with us. But even if you don't decide to work with us, we're happy to meet with you for an initial meeting, which we call a life and legacy planning session. Our life and legacy planning session is a 2-hour meeting, potentially up to a 2-hour meeting, to get clear on what would happen now in your situation. And then if you decide during that meeting that you want to go forward, then we would design your plan during that meeting. That's why it's 2 hours. That's usually enough time to design your plan if you're ready for that and decide you do want to work with us. And as long as you do some homework before that meeting for watching this video, we will do the life and legacy planning session for free. Normally that's a $750 meeting. That's very valuable to get clear on what would happen in your particular situation. And then again, if you mention this video, we will also give you $250 off. Now that's for your initial scheduled appointment. After you reschedule, we no longer offer that $250 off. So call us today, either schedule a link directly. You can go to our website or probably a link in this post. You can also just call our office and our number is 907-312-5436. Again, 907-312-5436. Or go to our website and schedule that 15-minute meeting. We look forward to meeting with you for your life and legacy planning session to get clear on how your growing family may impact your existing estate plan or why you may want to get one in place.